各位委員
Members, it's the appointed time and we have a quorum. This is the Bills Committee on Chinese Medicine Amendment Bill 2017. Now we will elect chairman. Under House Rule 21(e) and also Appendix 6, we will now elect a chairman and a deputy chairman. A valid nomination has to be made verbally by one member to be seconded by another member verbally. This will have to be agreed by the nominated person. Ms. Kwok, I nominate Ms. Alice Mack, seconded by Mr. Xiu Ka-fei. Do you accept? Yes. Any other nominations? Any other nominations? Then I count to 3. 1, 2, 3. Ms. Mack's elected ipso facto. Do we need a deputy chairman? Ms. Mack, would you please come forward? Do we need a deputy chairman? No? If that is the case, we will start the meeting. Let's invite the administration to come in to join us. Please refer to the electrical brief issued by the Food and Health Bureau. File reference FHB/H/24/24 and also the background brief from the Secretariat, which is CB/21883/16-17/05, as well as the Legal Service Division Report number LS75/16-17. On the 14th of June, the government introduced this bill to empower the Director of Health to issue Chinese medicine safety order. As the Secretary said in the when he moved the second reading in March 2014, based on the public health reasons, the Department of Justice instructed a licensed wholesaler of proprietary Chinese medicine to recall 2 suspected unregistered PCMs, proprietary Chinese medicine, from the market. However, the wholesaler applied to the Court of First Instance for leave to challenge, by way of judicial review, the decisions of the Director. In May 2015, the CFI handed down a judgment saying that the Director had no lawful power under the Chinese Medicine Ordinance Cap 549 to instruct the wholesaler to recall the products in question. And the decision to issue the recall order was ultra-virus. Although under the existing ordinance, licensed traders of Chinese medicine are required to set up and maintain a system of recall for PCMs. However, the Director does not have power to instruct these traders to recall Chinese herbal medicine and intermediate products. We have reviewed current legislation and found that there is no statutory power to issue order to issue recall of Chinese medicine sold by traders without a license, as well as Chinese herbal medicine. So when it comes to Chinese herbal medicine and intermediate products, if they pose a threat to public health, then under a Chinese medicine safety order, the sale of these products will be prohibited, and the sale of these products and related products will have to be recalled. At the same time, we introduced an appeals mechanism. Those who are covered by this safety order may lodge an appeal to the director to ensure that all cases are dealt with in a fair and just way. We'll also specify that Chinese medicine safety order, revocation order, and variation order and the relevant powers will have to be clearly specified for all parties to understand the process involved. We will also propose to amend the CMO as well as the regulation in relation to service. We will also amend Cap 549F in relation to setting up of a management system, so that products in question will be effectively and efficiently recalled. And people who are regulated by the CMO Chinese Medicine Ordinance will have to abide by the provisions. Any non-compliance will result in a level 6 fine, that is $100,000, and 2 years imprisonment. The proposed penalty is similar to other penalties under the ordinance. In January and February, the Department of Health consulted the trade and the public for 7 weeks. The Department of Health had a meeting with 16 Chinese medicine associations and organized 6 briefing sessions for licensed Chinese medicine traders. The departments received in general support the legislative proposal and agree with that. On the 28th of February this year, we have briefed members in the panel about the proposal. In general, members supported it. This fully reflects, the proposed amendment fully reflects the views of the trade. This is to ensure public safety. We have got the support of the trade, so I ask members to support this bill so that we can, as soon as possible, improve the regulatory regime of Chinese medicine in Hong Kong to give better protection to the general public. I'll be happy to take questions. There aren't many members in this committee. Maybe there won't be any time limit for the first round. However, if there are more names, I might set down a time limit. First, Mr. Ben Chan, to be followed by Ms. Helena Wong. Yes, there's a need to amend the CMO, and we support it. And it should not be limited to recall order. When it comes to problematic PCMs, the director does not even have power to order recall. We can see that this ordinance is fraught with flaws. The trade has commented on a number of occasions that definition of Chinese medicine is problematic when unregistered PCM is found in the market. Say, for example, with some addition of a vitamin C, you can't regulate it because it's treated as a health product. However, save and accept the vitamin C, everything else is Chinese medicine, and you don't have the power to regulate it. So I do think that this piece of legislation is flawed. Ever since the enactment of the CMO, not many PCM successfully got registered. Even traditional medicine or prescription can't get registered. Now you identify some problems, and you only you only fill in the gaps as you find them. We give you power. We will endorse this proposal because there is a court judgment. There are about 7,000 PCMs waiting for the application for registration to be processed. The Ombudsman at the moment is conducting an investigation. So would you take the initiative to amend the entire bill instead of waiting for the Ombudsman? Instead of waiting for the Ombudsman to find something and then you will rush to remedy it. So will you deal with it in a proper way? Mr. Chen, as I said in my opening remark, this amendment is pursuant to a court judgment. That's why it's a bit of a rush. We constantly review the CMO. The member mentioned about definition of PCM. We have taken the initiative to do some research and study. Under the Chinese medicine regulatory board, there is a Chinese medicine group, and there is also a dedicated group looking into this issue. We hope to conduct studies and make recommendations in relation to definition of PCM. I will defer to Dr. Cui. As my colleague said, the Chinese medicine unit under the board expressed concern about definition of PCM. So in the Chinese medicine unit, we have set up a working group comprising of representatives of laboratories, Chinese medicine practitioners, and also the trade. And this is to collect views of all the parties involved if we are to change the definition. Can I have the composition of this working group? In the past, perhaps the Chinese medicine unit might have done some review, but the scope of Chinese medicine is quite wide. Some are involved in trading, some are involved in manufacturing, some for sale, some in sale, and some just express an interest. So the scope is quite wide. So I want to ask you, who are these experts that you have invited to join this working group under the Chinese medicine unit in the Chinese medicine board? PCM is a traditional industry. If we can involve more people, then the ordinance will be more comprehensive. Is it the case that we can maybe review and follow up? Will you invite people to participate? Say, for example, Mr. Siu Ka-fai, who is very concerned about this. Maybe we will invite the chairman to follow up on this matter, so that there will be sufficient discussion and sufficient comments expressed. Mr. Chen, can you tell us about the scope and also give us a detailed list of the of the expert group.
What about the consultation effort? Can you give us a list of organizations that you consulted? We conducted the consultation at the beginning of this year in relation to this recall order. It was quite extensive, and we can provide further information. As for the expert group, in incorporation of different views into its work, we also agree to the approach, and we'll see how we can incorporate different views of the community, including members' views. And this will be our work for the next step. So next, Dr. Helena Wong, and then Mr. Peter Shiu. Thank you. Madam Chair, I'm very concerned about proprietary Chinese medicines and Chinese herbal medicines. And we therefore agree with the recall order. We have a recall order for food, but not for Chinese medicines. At the same time, I also agree with Mr. Ben Chan, because there are still a lot of problems with the ordinance that should be subject to review. And you're only picking on one flaw. Can you tell us in greater detail how you're going to deal with them? What problems do you acknowledge at the moment, and also concerns of the trade? And what is your next step in relation to reviewing the whole ordinance? And what loopholes are you going to plug in the next stage? In relation to the CMO, I would defer to Dr. Choi to give you the views of the trade. The trade, including the Chinese medical practitioners and traders of Chinese medicines, we have had the exchanges with them, and we hold monthly briefing sessions with them. During the sessions, the trade would give us their views on the operation of the trade and the review of the ordinance. In relation to Chinese medicines, in the recent meeting, we had representatives from the Chinese medical practitioners, manufacturers, and sellers of Chinese medicines, and they hold different views on the Chinese medicines. For example, for the definition of Chinese medicines, the medicines should be used under the instruction of a Chinese medical practitioner, and there are divergent views on this point, and we'll continue to engage the trade in this discussion. As for other matters in relation to, say, for example, licensing, whether the license period can be lengthened. At the moment, it is 1 of 2 years, and the view of the trade is to extend it, and we'll have an in-depth discussion, because we have to draw reference from the licensing arrangement for Western medicine practitioners, and also the definition of Chinese medicines, and we'll continue to engage the trade in the discussion. And so apart from the definition of Chinese medicines, they also have divergent views on the licensing arrangement. Can you tell us more about licensing? Are you talking about the license for importers of traditional Chinese medicines, or wholesalers or retailers, or registration of the medicines themselves? Under the CMO, there are 4 categories of licenses. The first is manufacturer license. The second is wholesaler's license. And the third one is wholesaler of Chinese herbal medicine. And the fourth one is manufacturer of Chinese herbal medicine. And each license carry a period of 2 years, and the trade's view is to extend the license period from 2 years to longer. What's the difference between the third and the second categories? That is the difference between PCMs and CHMs. Well, in the ordinance, there are 2 kinds of Chinese medicines. The first one is Chinese herbal medicines, CHMs. The other one is PCMs. proprietary Chinese medicines, meaning processed Chinese medicine like ointment or pills. So is the importer required to be licensed? Dr. Choi, at the moment, for the import of PCMs, that is covered under a wholesaler's license, whereas for CHM, a wholesaler's license is required. So does wholesaler mean importer? Under Cap 459, for import of Chinese medicines, the license is required for both CHMs and PCMs. So how many licenses of CHMs wholesalers are there? I'll provide the information later, Madam Chair. Well, Madam Chair, I don't think we should just look at a certain area of the bill because members need to understand thoroughly the regulatory regime that we have at the moment to see, first, whether it is reasonable, and two, whether it is sufficient. According to the background information given by the administration, it seems that the Bills Committee is not given any assistance in examining the bill. So let's take us having no knowledge at all, because the public will also need to know the implications on them. We would like to know what this bill does, and then let the public know at what stage will the public be engaged. With the help of the members, we can improve the ordinance. I am very concerned about the safety of PCMs and CHMs. Without the information I just requested, I think it's difficult to carry on the discussion. Can you just pause here and let Mr. Peter Shill speak first, because you've spent 10 minutes. Well, will the administration give us figures in relation to the 4 types of licenses and the list? Yes, Madam Chair, we can. Mr. Peter Shill. Thank you, Madam Chair. The court already handed down a judgment. So in relation to the bill, we agree with the proposal. But we as the trade, as discussed last time, are concerned about the recall order and about the scope of the order. So I'd like to have more information from the administration. Assuming that the supplier has already issued a notice to the so-called frontline retailers or wholesalers asking for recall of the products within a certain time frame, and if the recall action has failed, where does the responsibility lie? The recall mechanism has been all along been implemented through administrative means. When a director issues a recall order, the majority of traders follow the order, and they're clear about the whole recall procedure. Under the existing ordinance, when a director makes a recall order, the person to whom the order is served, say the wholesaler, will be targeted. So the wholesaler will be responsible for carrying out a recall action by drawing up a plan and implementing the plan. And this only targets the person whom the order is served. For other parties not covered in the order, they would need to work with the wholesaler. But I can defer to Dr. Choi to give you more details. For the 3 categories of licenses, meaning the wholesaler of CHM and also manufacturer and wholesaler of PCMs, at the moment they are required to set up and maintain a recall system. At the moment, we do not have a recall order mechanism in place. In the past, we did carry out recall actions, and each case should be considered on its own merits, because the quantity of medicines and the retail network are different. So on each occasion, we discuss with the trade relevant to the medicine in question on how the recall action should be carried out. In the past, recall actions were carried out very smoothly. But if the medicine has been sold to a member of the public which has been consumed, then no recall action can be carried out, and this is reasonable. It depends on the retail network and the channel of recall, and we need to consider all these factors. In relation to this recall order, we already explained to the trade that the system of recall remains the same, and the licensed traders should not be worried about the implications of this order on them. On the other hand, for unlicensed traders, the new order will help us recall the products effectively from the market. Mr. Xu. Well, Dr. Cho, you mentioned that at present there is a set of guidelines on recall actions. Can you tell us how the products are to be recalled, and is there a time frame, or what happens if not all products are recalled? We came across 10 cases of recall in the past, and as we mentioned, each time the quantity and the amount sold are different. It is difficult to set a percentage of recall. But in past recall actions, we had to understand thoroughly from the trade features of the product, for example, the batch numbers and the distribution network. And the trade will, within a week, let us know the number of products recalled, and then we'll consider whether the quantity is reasonable or not. And judging from experience, within a week or two, the trade would be able to recall the necessary products. Well, you said that in 1 or 2 weeks' time, in these 10 cases, the products will be recalled. How many percent of products were recalled? Or what is the percentage that you considered reasonable? As I mentioned, we do not have a percentage in mind. Let's say if the product is very popular and that very quickly when it is launched in the market, the product is sold and consumed, then it's impossible to recall. That is why we do not set a fixed percentage on the products to be recalled in order to be considered to be reasonable. But of course, if the quantity sold is smaller, then the product still available in the market will be more, meaning that you'll be able to recall more products. It is difficult, therefore, to set a threshold as to whether the quantity recalled is reasonable. Mr. Xu, well, about the 10 cases, in fact, if they did not follow your instruction to recall the products, they were not contravening the law, meaning that they would not be fined or imprisoned in any way. Dr. Choi, we do not have a penalty in relation to the recall order at the moment. This has been done through the licensing mechanism. As I mentioned, we have the manufacturer and wholesaler of CHM and also manufacturer of PCM, and they are required to follow the guidelines issued by the CMB, Chinese Medicines Board. Otherwise, we'll be subject to a disciplinary action, but not penalty under the law. I ask this question because you mentioned that in previous cases the same recall action was carried out. But in fact, the trade did not have clear instructions on carrying out recall actions. And in fact, the most serious punishment would be a disciplinary action. But let's say if you're unable to recall at least, say, 50% of the product, or that you are late in carrying out recall action, etc., you'll be fined you'll be subject to a fine at level 6 and imprisonment for 2 years. And this is a concern of the trade. Well, I asked the question a number of times already. It seems that there is no fixed percentage. It is determined by individual cases, and in fact, if you follow the guidelines, you only be subject to disciplinary action. But now it will be facing a fine of $100,000 and imprisonment of 2 years. So you need to be clear about it for people not to be inadvertently caught by the law and be sent to prison.
Perhaps we'll hear from Mr. Chen before I ask Mr. Ben Chen to ask further questions. The recall guideline is made public. I can give a copy to members. In the guideline, you will find detailed information included. If there is a need to issue a recall order, well, that actually is not the first step. First, there will be administrative request to ask the trader to formulate a recall plan. It's not something that the Department of Health imposes on them. The plan will be formulated after discussion. So first of all, there will be administrative recall, and there has been some successful cases as well. The discussion will continue even with the legislative proposal. What changes is that unlicensed traders and also unregistered medicine, because the director does not have power to order a recall. This legislative amendment will cover unlicensed Chinese medicine products to protect public health. You say that there is a guideline, but each case is different. I know that Dr. Choi is in close communication with the trade. Perhaps we can conduct a public hearing. Yes, we'll ask questions about that later. Next, Mr. Ben Chen. With the legislative amendment, there is the power to recall and a prohibition order. I know that in the past the DFH has conducted recalls. It looks like there was no legal basis. What about those past cases subject to recall? Would they ask the administration for compensation? The past 10 cases in the past 2 years, they have been done through administrative measures. The Chinese medicine traders accept the DFH, the proposal of recall from the DFH, because if it's something that poses hazard to public health, they don't want to see it circulating in the market. When this amendment is passed, if traders refuse a recall, then the director will issue an order. This is not the first step for the director to take. It's only when it can't be done through administrative recall that the director will issue this order. I asked the question because about 2 years ago there was this medicine. The DFH asked the trader to recall it, and I found some information, and I told the DFH that they didn't have any power. They told us adamantly that they had the power, and in the end, of course, for the sake of public safety, the trader followed the recall instruction. At that time, they told us adamantly that they had power, but now it's found that they actually did not have power. And if they, at that time, force a recall, well, would it have subject the administration to possible compensation? The judgment was handed down in May 2015, and before that, the director thought they had the power. And subsequent to this judgment, we propose a legislative amendment. Perhaps Mr. Chen can give us more information about this case. There is another question. This is about unregistered medicine and Chinese medicine that is not Chinese medicine. But there are a lot of suspected Chinese medicine being sold as food with 7+1. So will this bill cover them? Under our proposal, there is no change to the definition of Chinese medicine and Chinese medicine product. So we will follow the existing definition. As I've said, that the definition under the CMO will be looked into by the expert panel. If need be, we will make another legislative proposal to deal with that. The expert panel, I've asked people from the trade. You said it only covers some representatives and is not widely, the trade is not widely covered. So I ask you to invite representatives throughout the spectrum to give you comments, so that the ordinance can be improved in a better way. And I also hope that different people from the trade can attend the public hearing. Any timetable in relation to your review? We will look into how the expert panel can be more representative. For the other matters, I'll defer to Dr. Choi. First, I will reply in relation to the expert panel. This panel is a special group under the Chinese Medicine Board. I've told you about the composition of the expert group or panel. They will make recommendations to the board. The board comprises of Chinese medicine practitioners, representatives of universities, and the general public. We will also conduct extensive consultation. We will only act after public consultation. And I would also like to reply to Mr. Chan's question about recalls. We found through lab testings that certain products may pose hazard to public health, and then we will talk to the traders to find out why there was a problem and how the product could be removed from the market so as to protect the public. And the DOH were very well informed about the purpose of each recall. In the past, our work is based on the guideline of the Chinese Medicine Council. We will need to further talk to the trade about the to collect their comments about the ordinance before we can work out details as well as the timetable. Next is Ms. Helena Wong. Thank you. I would like to follow up on the previous question. You said there were 4 types of licenses. I would like to focus on Chinese herbal medicine and also PCM. You have retailers, licensed manufacturers, and also wholesalers. How come there is none for importers? I am thinking from the perspective of food safety. Food safety is import, wholesale, and retail. The Center for Food Safety will take samples for testing. If there is a recall, then they will have to be done on the retail level, wholesale level, as well as the import level. You treat importers as wholesalers. What is the reason? How come import of Chinese herbal medicine or PCM that does not have to be covered by an importer's license? Let me first answer about the number of licenses. For wholesalers, 935, retailers, 4,688, manufacturers, 274, wholesalers, 1,101. There are 4 types of licenses. When something is imported, they will be done through wholesalers. Import of Chinese medicine will have to be covered by an import license. When it comes to Chinese herbal medicine, there are 31 toxic substances in Schedule 1 and 5 in Schedule 2. They have to be covered by import licenses. Well, you don't require importer's license, but you would require an import license covering the items, right? There are 31 toxic herbal medicine. So altogether 36 Chinese herbal medicine with a high toxicity that have to be covered by an import license. For the rest, if the content of heavy metal or pesticides or sulfide or hydrogen sulfate is too high, you wouldn't know. I know that every month you will take 30 samples, is that right? Every month we will take 45 samples from the market to test for residual pesticides and also heavy metal. And we're also concerned about improper mixing of herbal medicine. There are currently we will conduct 45 tests. In the past, we conducted market surveillance at the retailers level. Now we also cover wholesalers level as well, so that we will know when something happens. Over the years, we have not found any Chinese herbal medicines that exceed the limit for heavy metal or residual pesticide after they've been prepared. Well, whether they are PCMs or Chinese herbal medicines, they are to be consumed. So yes, you will take sample on the wholesaler in import, wholesale and retail. You only take 36 samples covering what herbal medicine. What kind of heavy metal do you test for? What residual pesticide do you test for? Can you give us more information? And I think the crux of the problem is that you have to tackle it at source. But if there are no problems at the import levels, then there won't be any problems at the wholesale and retail level.
So as long as the products are saved, you do the gatekeeping at the import level, and if the products are safe, then it can be distributed to consumers for consumption. But the point is, you're being too lax at the source, and then you're trying to catch them. I mean, there are 4,688 retailers and also 1,101 wholesalers of PCMs and CHMs respectively. It is absolutely difficult to tackle the problem at the end point, and it is not effective either. My take is that you need to do a more stringent gatekeeping job at the import level, because if there are some 900 wholesalers who are licensed traders and de facto licensed importers, then after the products are imported, well, the retail sector will not have any knowledge, and they will not specifically test the products themselves. I want to point out that what you're doing is not effective, and you're not targeting the right culprits. You need to do a stringent gatekeeping job at the import level and step up sample checks. My other concern is about your standards. Are there clear standards promulgated in the law so that members of the public or traders would know the prohibited substances in medicine or the relevant threshold? We're conducting another public consultation exercise on the level of heavy metal content in food substances, and the standards are being updated. And at that committee, I asked a lot of questions about CHMs and PCMs. I understand that your standards are very much out of date, and there is only one set of standards for food products. After revising the standards for food products, what about CHMs and PCMs? And for food, it is said that standards will have to be set for the ingredients of food, but not in the case of PCMs and CHMs. You say that only after processing would you check the content. Let's say if I represent the retail sector, like Mr. Peter Shiu, if you ask me to comment on your approach, checking only the processed products, of course I'd say you should check the ingredients. I hope that we can become a hub of Chinese medicines. We can develop Chinese medicine, but the law is so outdated. Can you tell us what standards are you using? Are you using the mainland standards or the Department of Health standards? Because the Department of Health standards are so full of flaws, and there is a lack of standard for many substances. Mr. Chen, well, perhaps on the import of CHMs, I'll defer to Dr. Choi. At present, in relation to the relevant standards on heavy metal content and pesticide residues limits for CHMs, the standards are available on the website, whereas for PCMs, the gatekeeping that we do is that we need to make sure that they are not harmful to human consumption before they can be allowed to be sold in the market. And the trade is also aware of the testing standards of CHMs. In 2014, 15, 16, we inspected about 380 CHMs. So in the past few years, we inspected over 300 types of CHMs. Now, we understand that at the moment, only about 300 plus types of CHMs are available in the market. So we've basically covered all the available CHMs categories in the market. In terms of Chinese medicine, PCM or CHM, we also have a Chinese medicine standard, and we invite international experts to review our standards. It may be quite difficult from it will be quite different from food products. It's not directly consumed, and that is why international experts in our expert group also agrees to our two-tier procedure. We'll start with the testing of raw CHMs, and if they do not exceed the standards, then we should not be concerned. However, even if even if the raw CHMs exceed the standards, it doesn't mean that after processing the standards will still be be breached. So that's for reassuring members. In the past, in testing CHMs, in terms of our risk assessment effort, we have not found any CHM that may pose a threat to public health because of the limits being exceeded. So we need to consider the level of risk and the quantity of CHMs to be tested and strike a balance. Well, can you give us a paper on the criteria of testing Chinese medicines? You talked about some 300 types of CHMs being tested in the past 2 years. So if possible, give us information to let us know what you have done. Mr. Peter Shiu. I'd like to follow up on Mr. Ben Chen's question about the scope of regulation of PCMs and CHMs. Let's say if some ingredients are added to the products like vitamin C or other vitamins, then the whole product will fall outside your scope of regulation. And in that case, how can you recall these products? Madam Chair, at the moment, if the product doesn't fall within the definition of Chinese medicine in the ordinance, it will not be affected by this bill. That is to say, if they are not defined as PCM or CHM under the ordinance, they will not be subject to the new regulation. However, as I mentioned, under the Chinese Medicine Board, we've set up an expert group, and we're reviewing the definition of Chinese medicine, and we would consider revising the definition after consulting the trade. So can this also be done in this exercise? The answer is no, because if there is any amendment to the definition, we must extensively consult the public and the trade before we have a definition acceptable by all, and it will take time, and therefore it will not be covered in this legislative amendment. I ask this question because in the trade, they're concerned about this. For the testing of CHMs or PCMs, they are required to follow all your instructions, whereas in the market, there are already products with packagings very similar to the PCMs, and they might even have used the same formula. The only difference is that they have added some substances that are not harmful to humans. For these derivatives, they're not regulated, and the products might let the public to believe that these are Chinese medicine, but in fact they are not, and they are widely circulated in the market. I'm not commenting on whether the products are good or not. Perhaps by adding vitamin C to the product may be more effective, maybe not. But the point is, there are already such products available in the market. I won't comment on the market share either, because this is about conducting business. But from the public's perspective, if the administration doesn't do anything about it until later, it will be unfair to the traders who are selling the traditional PCMs, because these products are similar. So won't you think that it is not very fair to the traders? The so-called Chinese medicine supplements, I do agree that there is a gray area, and it may not be captured by the ordinance. But as long as they meet the definition in the CMO or the definition in the Pharmacy and Poisons Ordinance, then they will be required to be registered. Whereas if there is any claim or statement that the product can prevent disease or can be used for treatment, it will also be captured by the relevant law in relation to advertising for medicines. And for all kinds of oral supplements, they will also be subject, their statements in the advertisements will also be subject to trade description ordinance and other pieces of legislation. So it is not the case that they are not caught by any law. As for the products that you mentioned, Chinese medicine with supplements, then this is being looked at by the expert group of the CMB. Mr. Shiu, I repeat, I'm not suggesting whether these products are effective or not, whether they're good or not, because we don't know. But from the public's perspective, well, you talked about a trade description ordinance, but they do have very similar packaging. How can we differentiate? We don't know the efficacy. Well, for one product, the regulation is very stringent. It's caught by the CMO, whereas for the other product, it is not caught by any regulation or ordinance at all. So about the PCM, will you consider requiring a label to be affixed stating that it is a PCM? As for the other kind of product I mentioned, you require a label stipulating that it is not a PCM, because we need to be fair. If you want the public to be safe in buying these products, then the PCMs should follow your instructions and go through testing, etc. Whereas for the other kind, if they don't wish to follow your instruction, there should be a label stuck on the box saying that it is not a PCM. Well, if it is a genuine PCM, it will have to be registered with the product with the registration number stated on the product. And the Department of Health also proactively checks products in the market to look for counterfeit products. I'll defer to Dr. Choi. Well, at present, we require all registered PCMs to carry a registration number starting with HKNT and HKP and HKC, and we have also launched public education, and that the public must first understand whether the product used for treatment or prevention of disease is registered or not. If it is not registered, then the public should avoid using such products for treatment of diseases. And we'll also check the market to see whether there are counterfeit products or quoting the incorrect registration numbers to claim that it is a registered product, which in fact it is not. Well, we talk about the HKC and other kinds of registration numbers, so you can check against your list to see if genuine. But from the public's perspective, do you think the public understands what it means? It has to do with knowledge and the public education. I can tell you that the majority of the public doesn't understand. Because for you, you can just check the registration number against your system. Whereas for members of the public, they don't know that in fact this is not a PCM but a health supplement. So there is already confusion in the local market, and not to mention the foreign tourists, foreign shoppers. For locals, they find it so difficult to differentiate the products. Only a registration number is available and no details provided. So as to allow the public to make comparison with other products, it's confusing. So my suggestion is to have a label stuck on a box saying that this is a PCM, whereas for the other, it is not a PCM, it is just a health supplement.
Perhaps some people may complain, but if they want to take the market of Chinese medicine, then they will have to follow your system. It is unfair to the trade, and it's not fair to the public either. The director is empowered to require all licensed traders to make a registration and to follow requirements in relation to labeling. When it comes to PCMs that are taken orally, there is no relevant requirement. And if there are undesirable medical advertisements in their advertisements, we will use this piece of ordinance to deal with it. The DFH needs to enhance public education to help them differentiate what is PCM and what is not. We hope that the expert group will expedite their work so that we will be able to improve the law as soon as possible. Ms. Wong, I would like to ask about safety standards of Chinese herbal medicine. Just now, they said that every month they will take 45 samples. In the past, there were only about 30. Can you give me information about samples you've taken every month? That is, whether they are taken at the retail level or wholesale level. What are the samples? What tests have been done, and what are the results for the past 2 years? Dr. Choi, I'll give you the information afterwards. I have another question. It was asked before but not answered. We want to tighten food standard in relation to heavy metal. It will be tightened from 10 milligram to about 1. So in relation to Chinese herbal medicine, will there be corresponding updating? What are the reasons? We are aware of the change when it comes to food safety standard. We constantly review standards and limits of residual pesticide and heavy metal of Chinese herbal medicine. We take into account limits in relation of Chinese herbal medicine or herbal substance in other countries, and also that of World Health Organization. We also have an expert group monitoring that. The only difference is that when it comes to food, there is codex. when it comes to Chinese herbal medicine, there aren't many institutions or organizations that will set limits for heavy metal and residual pesticide. So we will refer to information of the WHO and also the international standard. We will also keep under review whether there is a need to update information. We will every year keep under review whether there is any need to update the limits and standards. Well, when will you conduct the review? Because if your expert committee doesn't do anything, then that means there is nothing we can do. The DOH will review the limits of heavy metal and residual medicine, but it may not be corresponding to that of food or the standards set by Codex. And we will keep in view whether there needs to be any changes. Well, can you give me a list of names under the expert panel? Any minutes of meeting to let us know about the considerations you have taken into account and your discussions. Well, yes, they are different, Chinese medicine and food, but they are both ingested. You want to protect public health, and you want to recall problematic substance. So I don't think the public would not oppose to that. Well, for food, the limit will be tightened. And if the limits or standards of Chinese herbal medicine it lags behind, then there will be a problem. We have chronically ill patients who rely on Chinese medicine in the long run. And I was asked questions whether it's safe to take the Chinese medicine. Say, for example, cancer patients. I can't understand why you adopt this approach. Well, this may not be directly related to this legislative proposal. Just give me more information about the list of experts in the group as well as minutes. Yes, in relation to what we will give you an information paper about the list of experts in the group as well as the discussions they have had. All the questions I've asked are related to this bill. There is a need for the recall for the safety order because you need to protect public health. If the administration wants to make a recall order, you have to make sure that both the traders and the DOH agree on all the issues. You need to set limits and standards if there is no standard, then it will be difficult if you make a recall order. And I asked about Chinese herbal medicine, whether it is raw and in its original form, or whether it's been reduced and processed. Well, if the limits have been exceeded in its original form, but not when after it's processed, will there be a recall? So which will you use, the original form or after it's been processed and prepared? They are all related. I hope you will understand why I ask all these questions. It is meaningless to empower the administration to make recall orders without clarifying these issues. Well, limits are not tightened under this bill. Currently, the standards are clear and the trade knows very well about it. We always follow the same standard. The DFH has already answered that there is an expert panel reviewing the latest international standard of Chinese medicine and PCM. We will give you an information paper. Just now the member talked about standards. We use a two-stage testing. First is the sample of Chinese herbal medicine to see whether there is any toxic substance. If so, there will be a stage 2. If there is any exceedance, there will be a stage 2 testing. That is, when it's processed and made into soup, just like when members of the public will, the form that members of the public will take to see if there is any exceedance. Then an assessment will be conducted on the health risk before a decision of recall is made. You have an information paper? Yes. Can you give us it? We have provided the information to the Health Services panel, but we can give it to you again, yes. Mr. Ben Chen, I agree. Because food and medicine are completely different, because it takes 6 years to grow ginseng and just about a few weeks or a few months to grow vegetable. So the heavy metal content will be different as well. So if you use the food standard and apply it to Chinese herbal medicine, it doesn't work. And you can't take Chinese medicine every day because that is not advised. It will be a heavy burden to your liver to take Chinese medicine every single day. You need to set standards, yes, but you also need to take into account reality. If you say something growing for 6 years will have the same limit level as vegetable, that will be unfair. A member mentioned about the addition of a certain substance, and then it is no longer Chinese medicine. I have now this PCM. It's for women. It contains chicken, bird's nests, and some Chinese herbal medicine. They are all Chinese medicine, so I wonder why it doesn't require registration. I've asked some experts. Well, they said it's chicken. Because for the rest of the world, chicken is Chinese medicine, save and except one particular type of bird, turkey. This medicine I have in my hand is made with turkey, so it is It doesn't require registration. There are 3 ointments, 3 medicinal oil here. It contains many different types of Chinese medicine. It also talks about efficacy to relieve muscle tension, fatigue. It applies to everything. However, I don't find any nutrition labeling here or any registration. There is another PCM here. Is also a rubbing oil with efficacy all stated, no registration, anything. The third one's got registration, and the one with a registration is cheaper.
So for the unregistered PCM, it is even more expensive than a PCM registered. Imagine the cost of registering a PCM. If we do not amend the legislation, we cannot recall these products, and that is why we support the bill. But together with these tin hay pills, we understand how absurd the ordinance is. And I also have 2 intestinal pills. One is Li Man Shan, the other is one from Singapore. These 2 are for treating intestinal ailments, and these 2 products are similar in their packaging. And my colleague suffers from a stomachache, and the dispensary recommends this product, and we find that this one is more expensive than the other one. This one this one is very effective, but it is not registered. It is still available in the market. For the other one, this one is in fact registered under the as a Western medicine because it contains Western medicine. For this one registered as a Western proprietary medicine, the cost is much greater than the other one. In your bill, you can deal with these 2 products, but not this one, not these 2. So I think that you should tackle more issues in the bill in greater depth so that the public would better understand the difference between registered and non-registered products. Now about this product, they have made a lot of effort, but at the moment it's just HKP, but not HKP, meaning that it's a provisional registration. Because it's really difficult to meet all the requirements. It comes from a formula for a Chinese medicine, and it's difficult to follow the standards for Western medicine. It has a compound prescription, and there is not even a standard for some of the ingredients. So I think that the board should also comprise representatives from the sector so that the difficulties facing the trade can be heard. Apart from the existing products in the market, for some new products, they can also be registered. Now for this bill, it is a step taken such that the Director of Health can make an order for recall of certain products, but I think that your group should have more members from the trade so as to incorporate the views of the trade, and so that you can table in the council another bill to amend the ordinance. I am chairman of the Committee on Matters Relating to Chinese Medicine. I just want to ask if the administration can go deeper in amending the law. I mentioned just now that the expert advisory board will extensively incorporate the views of the trade and consult the trade. As for the legislative timetable, we must obtain support from the trade first. We hope that in the coming legislative session we can report our progress to the relevant panel. Mr. Chen referred to different products that are not registered. We also take note of that, and that is why we have set up this expert advisory board under the CMB to tackle the issues. Mr. Wu Chi-wai, I just want to have an answer from the administration again. Now, this bill targets PCMs and CHMs, but in the market, like Mr. Shiu said, there are other supplements or other products for beauty or for treating ailments available in the market that claim themselves to have Chinese medicine ingredients, and yet they're not subject to regulation. And the so-called natural supplements, they're not required to be registered, and they can be sold in the market. And can we tell the difference between the nature of these supplements and Chinese medicines? Because for natural supplements, they may incorporate the ideas of Chinese medicine. For PCMs, however, they are required to be registered. I'd like to have your take on the matter. Dr. Choi. Under the CMO, the definition of the CMO is that first of all, Chinese medicine should constitute Chinese medicine that comes from plants or animals traditionally used by Chinese for treating ailments. And as for products, they refer to sachets of powder or pills. And the third element is that there should be a statement along with the product or claim. And for products meeting these definitions, they will have to be registered and subject to regulation under the CMO. As for the herbal remedy or natural supplements suggested by members, is not sure whether they also meet the elements in this definition. If so, they should be registered as Chinese medicine. In that case, in short, is there a complaint mechanism? And how can one make a complaint for you to check whether such a product is a Chinese medicine and should be subject to regulation? Or will you take a proactive approach to check and see if they should be registered? Another question is, if the product is problematic in the sense that the testing result is finds the product problematic, is there any way to deal with these products? I'll defer to Dr. Choi to answer your question, but the point is, if the product meets the definition of Chinese medicine under the CMO, and if it poses threat to public health, the director can make an order to direct that recall actions be carried out on either registered or unregistered products, or the relevant person will be criminally liable. As for random inspection, I'll defer to Dr. Choi to take your question. In our surveillance program, we do check the products available in the market and whether they should be registered as medicine, including Chinese medicine or Western medicine. And on receiving complaints, we proactively checked and see if the product should be subject to our regulation. So can I take it that if the product available in the market is not registered, that means you have checked and found that the product is not required to be registered as a Chinese or Western medicine? Yes, we try to identify these products in our market surveillance program, but new products are emerging very rapidly. So when we receive information, we will check whether they should be registered. How often do you do the inspection? And can you tell me more details how this mechanism operates? Maybe I can defer to my colleague, the senior pharmacist, to let you know more about the routine inspection and testing. Mr. Yong, we have inspectors carrying out random inspections on a regular basis. We hope to conduct inspection at least once a year on each licensee. And when a license is to be renewed, or when we receive application to change the address or the name of products, we will also conduct inspection. During the inspection, we check the products on scene, and we also see if they have registration numbers. For products not carrying registration numbers, if they fall within the definition of Chinese medicine, we take action. Now, you talked about traders, but does it include products found at the retail level? Let's say in Watsons and Mannings we see so many such products. Does your inspection cover these retail outlets? Well, we have been referring to traders, but we have a lot of retailers in Hong Kong, and we cannot make sure that our colleague can inspect each and every retail outlet where such oral supplements or natural supplements are sold. But on receiving complaints on suspected breach of the law, we can take action. Dr. K.K. Kwok. Thank you, Madam Chair. Well, first of all, I support the bill. But the problem doesn't lie with the bill. The most important aspect is enforcement. According to the Department of Health, I understand that there are 380 categories of products subject to your inspection efforts, and you would inspect the traders at least once a year. I want to know whether this is done on scheduled basis or not. I don't think it's sufficient, because if it's scheduled, then they would be tipped off and they would just hide all these suspicious products. If you do not have enough random inspections, it is futile, because first of all, not products on sale come from registered or licensed Chinese medicine traders. We have learned from media reports that there are products not registered coming into Hong Kong from unknown channels, and they are available for sale in the retail outlets, even supermarkets. So if you do not conduct random inspection, then I'm afraid your effort is futile. As for Chinese herbal medicines, unless you have a very stringent registration mechanism, that is, a certificate must be attached to each batch imported, certifying that it does not exceed the relevant heavy metal content levels or pesticide residue limits, it will be meaningless. So I want to know whether such a mechanism will be set up, in that when a batch of CHMs is imported into Hong Kong, it would need to go through a lab in Hong Kong for testing first, so as to safeguard public health. Third point on penalty. You have a level 6 fine and imprisonment of 2 years. And on the matter of fine, of course, court would not mete out the maximum fine of $100,000 for a trader. It's just a drop in the ocean because the turnover is in the sum of millions of dollars. So, would you raise the maximum fine? Because the court will not meter out the maximum fine anyway. You need to have sufficient deterrence in your penalty, along with sufficient random inspection and enforcement for the bill to have effect. So these are the three questions. Let me take the last question on penalty. We've drawn reference from other offenses and the penalty set out in the CMO, and we note that the trade's views. There is a question on whether the penalty is too harsh.
If we are to enhance the penalty, we will have to take a comprehensive look in the entire ordinance. We do think that the current proposal is suitable. As we've said, in the past 2 years, whether it's before or after the judicial review, the DOH has issued recall orders. And indeed, light traders all cooperated with the DOH to protect public health. So we do think that the chance of an order being issued is quite slim, and chance of non-compliance is slim too. We will start with a current level of penalty of the ordinance. After the our proposal is implemented, we will conduct reviews. Dr. Kwok talked about registration system and other matters. I'll defer to my colleague. We currently require all wholesalers of Chinese herbal medicine to procure from places with good reputation. Most of it comes from the mainland, and there is a GMP system practiced on the mainland. Under this system, all batches of Chinese herbal medicine manufactured will have to comply with requirements set down by the country, say for example in relation to toxicity. So traders are required to procure from places with good reputation. We require traders to keep all documentations for 2 years to facilitate tracking. As to whether all batches will have to be tested when they arrive in Hong Kong, we have to first conduct consultation, because apart from the views of the trade, we need to see if we have the capacity to deal with the testing. My question has not been answered. Would you take enforcement action at retail outlets? Well, certification and testing is one of the 6 industries where Hong Kong enjoys an advantage. You need to introduce better regulation. I'm not going to comment on the mainland standard, that is the standard of GMP on the mainland. You can start with importation from the mainland, but you should not give up on local regulation. I don't know how long it would take you to consider it. So the amount of tests you have done, and that done at the retail level, what are they? And by how much will that be increased? I'll first reply about testing. I don't rule out any possibility of any change. But when we consider a proposal, we need to talk to the industry, especially the testing trade. We have to talk to wholesalers and retailers And that will be included in our discussions with them. What about figures at the retail level? And I've also asked a question. Chinese medicine traders, do you do inspections with prior warning or not? I don't have the information about the first part. In relation to inspections, whether they are announced or unannounced, I will defer to Mr. Yong. All our inspections will not be forewarned. So they are on-the-spot inspections, all of them. Would you consider increasing the number of on-the-spot inspections to ensure compliance? Is our target to cover all licensed traders at least once a year? On top of that, there is another type of inspection. Say, for example, during renewal, we will conduct on-site inspection. And where there are changes with the company, say address, license holders, or name of the company, we will also conduct inspections. So that's why I said at least once for every traders. And all of these inspections will not be forewarned. Ms. Helena Wang. About importation of Chinese herbal medicine. The administration said that they will have to be procured from places with a good reputation. Can I get more information about GMP? Whether we have our own set of GMP on PCM and Chinese herbal medicine. And Chinese herbal medicine comes mainly from the mainland, and they have their own GMP. Can you compare the two systems? And also, please give me information about the wholesaler license of Chinese herbal medicine, 935 of them. From where do they import Chinese herbal medicine? Do they go through places with GMP before they are distributed? Has the DFH inspected these 935 wholesalers? And do they all comply with GMP? And if they don't, will it affect their license? What about the hospital authority? Do they procure from GMP places? I think so. What about a member of the public going to any Chinese medicine shop to get a prescription? From where do they get their Chinese herbal medicine? Do all licensed traders procure their ingredients from GMP places? From the perspective of Chinese medicine, there are two types of GMP. First, that covering Chinese herbal medicine, that is from when they are collected to processing. That is in relation to Chinese herbal medicine manufacturing. And we don't have this kind of GMP here because all manufacturers are grown in that place of origin and also processed in the places of origin. So we don't have manufacturing base here. The second is in relation to Chinese herbal medicine manufacturing, to turn in raw material into PCM, say for example into powder form, oil form, or pellet form. There are 18 GMP compliant manufacturers. And we have GMP for Chinese herbal medicine and also its manufacturing. we don't have manufacturers of Chinese herbal medicine that are GMP compliant. If that is the case, licensed wholesalers, that is the 935 of them, when they import items from the mainland, do they can they only do so from GMP compliant manufacturers? Out of the 935 wholesaler of Chinese medicine, we don't have any information which batch comes from which GMP factory. That means you have failed your job as a gatekeeper. They can get their goods from anywhere. There will be trouble here in Hong Kong. You talk about Chinese medicine pot and Chinese medicine hospital, but they may procure medicine from anywhere, and they can be sold in Hong Kong. You only take 45 samples a month. You ask them to keep documentation for 2 years. You need to check to see where they get their medicine or where they get their raw material. Chinese medicine hospital on the mainland would not allow procurement from unknown places. Why would you allow that to happen in Hong Kong? I don't agree that there is no regulation on sale. I asked you, the 935 wholesalers, do they obtain the goods from GMP places? You said you don't have the information. That means you are in the dark. Under the CMO, Chinese herbal medicine with toxicity will have to be covered by an import license from the D of H. For Chinese herbal medicine without any toxic substance, and they will be covered by the surveillance program to see if they contain residual pesticides or heavy metal that will affect public health. So we have a two-tier regulation. In relation to the 935 wholesalers, we'll see what information we can give you after the meeting. Just now, Mr. Howard Chan said something. He hasn't been a deputy secretary in this regard for a long time, but he made 2 mistakes. He said that he would only take 45 samples at the retail level. That is far from enough to ensure that Chinese herbal medicine sold here will not pose a hazard. And the toxicity standards applies to those you have listed in the schedule. There may be Chinese herbal medicine that are seemingly non-toxic, but it may contain toxic substance. When they are grown, and if that is not done under GMP, then it may contain excessive amount of hydrogen sulfide, or may be subject to contamination of heavy metal, or even residual pesticides. And they will all turn otherwise non-toxic substance into toxic substance. If you only regulate Chinese herbal medicine that are toxic without regulating others, and you don't ensure that importers will only import from GMP compliant places, then I see a huge flaw. We can't have our own import regulation. We have to take reference from other places. The DFH will adopt a risk-based approach. I will defer to the DFH. Dr. Cho. We take 45 samples of Chinese herbal medicine to check the residual pesticide and also heavy metal, and we also checked mixing of Chinese medicine. Over the years, we have not seen serious public health risk in relation to residual pesticide and heavy metal. When it comes to procurement, we require detailed information that every batch is subject to tests. Of course, that is ideal, but we need to strike a balance.
Because of our experience in the market surveillance, we don't see under the existing licensing mechanism or other regulatory mechanism any Chinese medicine products posing a major threat to public health, especially in relation to pesticide residues in exceedance posing threats to human health. Well, Madam Chair, you should know that the Democratic Party once bought some CHM for testing, and we are only a small political party. We do not have the means to do it on a large scale, but the testing results were really staggering. We had some kinds of herbs that have the pesticide residues exceeding the limit for many times, and we told the Department of Health about this, but I don't see anything being done. Well, I'll let Dr. Choi respond to your question first, but do go back and prepare a written response on your action against herbs with heavy metal content and pesticide residues exceeding the limits, your work on research and your work in engaging experts. Give us a paper on all these matters, especially responding to members' requests as to how you can step up monitoring and inspection. But you can give an oral reply first. But Madam Chair, I want to emphasize that for import, manufacturing and wholesale, you need to do random inspection. But the point is, you need to tackle the problem at source. If you don't regulate the source, it will be problematic because you have 4,688 retail outlets. My next question is, since we do not have a GMP in Hong Kong, good manufacturing practices, that is to say, if there is no such GMP in Hong Kong, and that we have one in the mainland, and the mainland has already been doing it because it has been attaching importance to the development of Chinese medicine and that all Chinese medicine is imported into Hong Kong from the mainland. My question is simple. Can you take the Democratic Party suggestion for the 935 Chinese medicine or CHM wholesaler? Can you make sure that the product they source from the mainland must comply with the GMP testing before they're imported into Hong Kong? Because at least there is one level of gatekeeping at that point. Can you make sure that this is done before the license is issued or renewed? After I allow the administration to respond to your question, I will allow Mr. Peter Shiu his turn to speak and then we need to adjourn the meeting because we need to adjourn the meeting at 10:30. But Madam Chair, what about the public hearing? Well, it's now July. I want to ask members if you want to do it as soon as possible or to wait until September or October. Madam Chair, next week we have a duty visit, and I'll be out of Hong Kong, and we asked so many questions just now. We need to allow time for the administration, the Department of Health, and the Food and Health Bureau to respond to our questions. So let's wait for the papers to be ready. How about the end of September? Perhaps the Secretariat can come up with an available slot in the end of September. But as long as it's not in the morning on the 2nd of September. All right, and then we can invite deputations to come to the public hearing. Dr. Choi would respond, and then Mr. Peter Shield will be the last member to speak. I will very briefly respond to the member's question. After buying CHM in the market, when we conduct the risk analysis, it will be done in accordance with the Chinese medical standards. We cannot apply food safety standards on Chinese medicine because, first of all, it is medicine, and for CHM, it's not normally consumed directly by ingestion, but rather by reduction into soup or processed. So when there is a quality problem with the CHM, we'll consider very carefully from the perspective of the product being a Chinese medicine whether this is a problem. Well, next Mr. Peter Shield, and then I'll let the administration respond, and I'll adjourn the meeting afterwards. I want to reiterate that there are a lot of good health supplements in the market. I often take them. But Mr. Ben Chan just now also showed us a number of samples. As you can see, in relation to certain products, their packaging are very, very similar to other kinds of traditional Chinese medicines. And these products are regarded as health supplements and remedies instead of PCMs. And I think that you should take note of this issue, because just now chairman of the political party, I forgot his name, right, Mr. Wu Chi-wai, just now asked this question. For these products, if they're regarded as Chinese medicine, you need to conduct tests according to the relevant standards, and the problem is, for the so-called remedies or health supplements with packaging looking really like the PCMs, they may have ingredients such as vitamin C added, and this creates a loophole as they are available in the market and the public cannot differentiate between these products. I won't say that these health supplements are not good because I don't know the ingredients. But for the traditional Chinese medicine, you should understand that the efficacy, many people have been using such products for a long time to treat certain conditions, to treat certain ailments, whereas for the other kinds of products I mentioned, they may have ingredients of Western medicine mixed in the product. But I think that the department should look into the matter as soon as possible, because the trade has been tackling with a problem of trademark infringement, etc. I agree that very often the supplement doesn't come in the form of oral supplements, but some products are similar to Western medicines as well. If there are no other questions, we'll wait for the Secretariat to let us know the time for public hearing. And if you think that the organizations or deputations should be invited to the public hearing, please forward the list to the Secretariat, and with the administration, please prepare for the written responses as mentioned. Thank you.